All right. I think we have everybody connected. So 1 second here. We'll go on the record. This is Charlevoix County case number 031723-19-CB. This is the matter of the Gale Corn Family Trust. And so if I can have all counsel put your appearances on. Mr. Findling, if you'd like to start as receiver, please.
Certainly. Good morning, Your Honor. David Findling, I'm the court-appointed receiver.
Good morning, Your Honor. Howard Shear on behalf of Sheldon and Gail Corn and on behalf of Shauna Corn.
Good morning, Your Honor. Kevin Smith appearing on behalf of Trustee Homer McClarty for the bankruptcy estate of Gail Corn.
Good morning, Your Honor. David Cleavorn appearing on behalf of Ashley Byron, formerly Corn.
Good morning, Your Honor. Dean Nelson representing Basil Simon, the Chapter 7 trustee of Sheldon Corn.
Okay, and Mr. Bowl, can you tell me who you're representing? You're muted.
I'm the CPA for the Corn Family Limited Partnership that filed the tax returns.
Great. Okay, thank you. All right, so the last time we talked was back in September. The court set this for, at that time, we agreed upon a 6-month period for the next status conference. So here we are. I guess, Mr. Findling, if you'd like to start, go right ahead.
Thank you. Your Honor, since the last hearing, Mr. Bowl was engaged and has prepared the partnership returns for the Corn Family Limited Partnership for the years that are of concern. Since then, the Internal Revenue Service has sent out their penalty letter indicating that the returns were filed late. After receipt of those penalty letters, I attempted to contact the IRS, and I think the court from the news probably has a pretty good idea of how difficult it is, if impossible, to reach anybody at the IRS, which was my experience. Before that, I had actually contacted a deputy section chief at the IRS U.S. Attorney's Office to see if he could assist me and give me a name. Unfortunately, he's lost a third of his attorneys, so he has not been very communicative. Today, I spoke with Mr. Bowl. He provided me with an accountant's telephone number that might help me with access. In anticipation of that, I prepared what's called a Form 56, which is the form for a fiduciary to communicate with the IRS. I've given that to my staff for filing so that when I call the IRS, they'll have me on record as being authorized to communicate on behalf of the estate. And that's where things stand from my perspective, Your Honor.
Okay, thank you. Mr. Shearer, Mr. Smith, Mr. Nelson, Mr. Cleavorn, anybody who wants to jump in from your side?
I guess I can go, Your Honor. So we asked Mr. Bowl to be on the status conference in case the court had any questions or any of the parties really had questions. I apologize, Your Honor. So as the court may recall, there really been, I guess, 2 primary open issues. One had to do with the tax returns, getting the tax returns filed, and then seeing what flowed from that, because we knew penalties were going to come as a result of returns not having been filed, back from like 2007, 17, 18 years, whatever it was coming forward. And we've alerted the court to that issue. The second issue had to do with the overpayment on the Lenchner judgment from KFLP of a little over $150,000. So on the one hand, I'm happy to report that Mr. Bowl did a yeoman's job, worked really hard. All the returns got filed, so we can check that off. But as we knew was going to happen, the IRS has assessed penalties against Corn Family Limited Partnership because the returns were all untimely. I don't know the exact number. It's anywhere from, I don't know, 140,000, 180,000, something like that, in that range. And there's some period of time where those penalties can be challenged, where the taxpayer can ask for an abatement, a waiver of those taxes. The parties have communicated, including communicating with Mr. Finling as receiver, because everybody believes that he's the person to seek those abatements. And I can't even articulate the frustration that I'm sure all of us have with Mr. Finling, not just because the returns weren't filed and we believe it was his responsibility, not just because of the overpayment on the judgment, but because he's the receiver and he has obligations not just to the judgment creditor who he overpaid, but he has obligations to the parties in interest, which includes the people on this Zoom call. And we've been sending him countless emails asking if he's even attempting to abate the penalties, what he's done to try to abate them, where things stand. And we don't even get the courtesy of a response email to say, I'm doing nothing. Here's what I intend to do. Here's what I've done. And it takes there to be a status conference with Your Honor to even hear that he's done the most minimal things, which seem clear to me that he's essentially done nothing until contacting Mr. Bull this morning before the status conference. So I don't know what the time period is to try to get those abated and whether we're even still within the time period. It's clear that nothing has been done yet. But where we're heading, Your Honor, is that if the penalties do not get abated, then, and I think I foreshadowed this at the hearing we had in Charlevoix a long time ago after this motion had initially been filed, and that is if the penalties do not get waived, then I envision that something will have to be brought before the court from our side to hold Mr. Finling liable for those penalties, because I can tell you that everybody other than the receiver believes that that fell squarely within his responsibilities to get those returns filed. And the fact that he never filed any returns has led to these penalties. I know that Mr. Finling has previously said that he believes it wasn't his responsibility. And so the court will have to deal with that. I think it'd be a good idea, and maybe Mr. Bull knows if Mr. Finling doesn't, how long we have to challenge those, how long we're going to wait before we bring this issue before the court. The second issue, again, was this overpayment on the judgment. The judgment has been entered, and I'm unaware of Mr. Finling having done anything to collect on the judgment. I actually spoke with Mr. Lenchner's attorney, Chuck Bullock, this morning, who tells me he hasn't even received a phone call from Mr. Finling about the judgment. But in any event, I note that Mr. Finling did not, in his initial statements to the court, talk about the judgment. He just talked about the tax return. So for me, you know, just the issues are, what's he doing about the judgment he overpaid? And where is he? Well, I guess we heard where he's at. Nowhere. He's now maybe starting to pay attention to the abatement issue. But that's where things are at from my perspective, Your Honor.
Okay. Any of the other counsel, Mr. Cleaborn, Mr. Smith, Mr. Nelson, want to weigh in for your clients?
Nothing much to add to what Attorney Scheer already added. I just think from my client's perspective, the priority is to keep this case moving forward.
This is Dean Nelson. The only thing I would like to add is that I actually believe we are lacking responses to some of the tax return penalty notices, and Mr. Bull may be able to speak to this because he was the one who filed them and gets that notice. But I actually believe there are 6 or 7 returns we're still waiting for a penalty to be assessed on while the time is ticking along on the ones that have been assessed. And so I think that will complicate matters. And again, I don't know the answer to that inquiry, so maybe I should stop talking and let Mr. Bull answer that question if he knows. But in terms of a timeline, that may add some, I guess, flies to the ointment.
Okay, and I'm gonna ask Mr. Bull that question in a minute, but Mr. Smith, was there anything you wanted to add? You're muted right now.
Sorry, Your Honor, nothing further to add.
Okay, Mr. Bull, can you answer those two questions, Mr. Nelson's question, but then the other question of what kind of time limits are there for challenging or seeking abatement of any penalties?
Well, Your Honor, let me explain a little bit the process also that we went through. Once we had the returns all signed and ready to go, we had to mail them. We could not file them electronically. So I talked to the IRS numerous times and told them this dilemma with all these returns. What should I do? How should I proceed, process? They said to mail each return separately. Don't mail them together because it would really get muddled up. So I mailed each of the 17 or 18 years of tax returns, separate envelope, certified mail, each one of them. And then what occurred was approximately a month or a month and a half after we filed the returns, we received penalty notices on maybe 5 of the tax years, and they were sporadic. They weren't, we went from 2007 through 2024, but the notices were rather sporadic. They didn't follow any type of continuity. And then I sent those on to everyone. And then maybe, I don't know, maybe 3 weeks later, we get another 3 notices, and then wait a little longer and a couple of more. At this point in time, there are still 7 years for which we've not received any response from the IRS regarding a penalty. I fear that for some reason, those returns may still not have got posted yet to the IRS system, because they have a habit of doing this when you mail stuff. That's why I'd send it certified. Things get lost all the time. They don't get posted into the system, and it's very frustrating. And I should call the IRS and this practitioner's priority line that I use and find out from them your records. Secondly, the amount of penalties so far assessed, I think, is around $95,000. Then to your last question as to how to proceed in trying to get the abatement. First, it's going to be somewhat difficult. I have done this for other clients, but it's usually maybe only 1 or 2 years. And to give an example, I have a client right now who has a legitimate issue for not being penalized for 2 consecutive years. I got 1 year already abated. The second year I've had to go through the appeals process, and it's still trudging through all that. With regard to this case, my wish would be that we could have like one focal party with the IRS that we could deal with. But that may not happen. In the bankruptcy world, we usually had the IRS district counsel that we could always go to and kind of work with and probably get some success in some way. Here it's a little bit different. And it's difficult also because we haven't received notices on 7 of these years. Now, when it comes to timing, I think it's important to get into the IRS now a letter requesting the abatement on all the years that we know of and start stating all the reasons why the penalty should be abated, which is going to be difficult because, again, the IRS is looking for good probable cause. You know, you were sick, or you were out of the country, or your wife died, or whatever the reason might be, that would be compelling for them to consider abating the penalties. But I think we should at least try and send the IRS a formal response. And that would, and then go from there and see what happens. Hopefully they,
Okay.
because you never know. You never know.
I mean, to your knowledge, is there under a statute or IRS code that sets forth a actual time limit? I mean, I understand that the urgency of getting something in there to preserve any possible objections, but I mean, is there a drop dead time frame?
No, there isn't. See, what also occurs, Your Honor, is that when these returns are filed, or any returns that are late, the computer generates the penalty notices. They don't even probably even looked at by a human being. They just go into the system, and right away, from the dates and everything, the computer generates the notice and sends it out. And from there, that kind of starts the process. So then you try to respond to that. But unfortunately, they don't give you a good address to respond, let's say with correspondence, because the address is usually some lockbox or PO box that generated the penalty notices, but you have to do it anyway. And then from there, you just keep on pressing forward, contacting the IRS, finding the best place to send your responses as to, you know, why you should try and get these, why you deserve to get these penalty notices abated, and then just keep going through the process. There's no time limit on it. Eventually, the IRS may start sending notices for levies and that stuff also. In fact, I'm surprised they haven't started sending that, but that's the next step on their end if there's no response. But we haven't gotten any of those letters yet.
Okay.
If
All right.
John, I thought there was either a deadline to pay the penalty, like in the notice of the penalties to begin with.
They want them paid right away, and that's why when you don't pay, then they wait a period of time and they start sending another letter requesting payment. And then if you don't pay, then they start sending the, you know, notices of levy or intent to levy, really, more than anything. But
I thought there was something in my head about 30 days, and then maybe you could extend it 30 days.
sometimes if you do contact them, they'll put a hold on things also. In this case, I believe I did get a 30-day hold on some of the years because I called the IRS to ask them again about this situation, and they said, well, they noted everything. You know, I'll just put on here to put another hold on these tax returns for another 30 days. Thank you. And I think I reported that to everybody. Good point.
Okay. All right. Any other the council have questions for Mr. Bowl based on what his comments have been here?
John, do penalties start accruing on top or interest on the penalties that are due?
Interest, yes.
And when does, do
Okay,
you know
so-
when that starts to accrue and at what percent?
Oh, the percent, don't, it floats all the time with the different, you know, treasury rates and that stuff. So I couldn't tell you what the interest rate is, but it's somewhere probably around the 4 to 6 or 7% rate, somewhere through there.
And if you looked at what the ballpark of what the total penalties will be once we get the penalties assessed on the other 7 that are outstanding?
I think I estimated, since we have about 95 now, I had done a chart, I think I sent to everyone. I think I was coming up in the $130,000 range. Now, the other 7 years will probably average about, because some back in 2007, and actually the penalty will be less than a penalty in 2017, because every year they keep increasing the amount of penalty per partner per month for a late return. So I would say it would probably average out to be about $7,000 or $8,000 a year in penalties for the last 7 years, something through there. Yeah.
Okay. All right, Mr. Finley.
Thank you, Your Honor. Well, I'm a little taken back by Mr. Shear's comments because the forms that I received from Mr. Bowl say nothing of the character that he has described. There is no provision or deadline for an appeal. I had not yet received all the documents. I've got the form from the IRS in front of me. I've looked at them before. With respect to my role, it was my understanding that I was going to attempt to abate the penalty. I was not going to be the accountant that, and this is in no way anything directed to Mr. Bowl, but rather that if Mr. Bowl felt that there was a deadline coming up, that he would let me know that we needed to take some action to ensure that we addressed it. And as what Mr. Bowl said, there is no deadline or any other concern right now about how we should proceed. Today, he indicated he thought it would be best that we send a letter. I'll work with him on doing that. It's not a problem at all. I have a disagreement with Mr. Shear about the things he said, and I don't think it's important that I address it now. Separately, with respect to his comments about Mr. Bullock, what he said is false. I can repeat what Mr. Bullock said to me. He was very hostile. He discussed the fact that criticisms of me and other comments related to my efforts to go after Mr. Lenchner's son, his company Jedi. I've already drafted a draft complaint to be filed against Mr. Lenchner's son. So the suggestion that I have not taken any action is not true. And his comment about Mr. Bullock is completely false. I know that I spoke with Mr. Bullock, and I can, like I said, I can repeat what he said. So I don't know why Mr. Bullock would say that I haven't communicated or spoken with him, because it's just not true. I'll answer any other questions the court may have. I understand everybody has discussed their frustration, but from my perspective, and maybe it's important that we address this now, with respect to communications with the IRS, with respect to any appeals or any further action that must be taken, I expect that Mr. Bowl, as the accountant, would notify me that there's some action to be taken. And that's in no way, in any way, disparagement of Mr. Bowl, but I just want to make it clear what my understanding is that I don't have an independent responsibility other than to mitigate whatever the penalties may be. So if that's not correct from Mr. Bowl's perspective, I would appreciate he cleared up for me. With respect to the penalties, I've already addressed that. With respect to the comments from Mr. Shear about recovering the overpayment, I've addressed that as well. Are there any questions the court may have of me?
No, other than what would be your suggestion going forward from today?
For me, from David?
Yeah.
Well, first, that Mr. Bowl keep me apprised of any actions that I am affirmatively required to take. Two, that within the next 10 days, we work together on drafting a letter that would go to the IRS with respect to a request for abatement. And that within the next 30 days, I will file a complaint seeking to recover the overpayment from Mr. Lenchner's son, where the funds were deposited from the overpayment.
Okay, thank you. Mr. Shear, your suggestions for going forward?
I guess number one, wouldn't hurt to have a directive from the court to let Mr. Finling know that when he's getting email after email after email, and Mr. Cleaborn, Mr. Smith, and Mr. Nelson didn't necessarily weigh in, but I'm sure they would all confirm the frustration that I've articulated, that I can't tell you how many emails that we sent saying, what are you doing with this? What are you doing with that? Where are you at? Have you sent something? What's your plan? And just, it's unbelievable that the posture of this case, with Mr. Finling hearing the frustration of all the constituents and knowing that we're looking at coming after him for personal liability, that he would continue to simply ignore all of us. It's just mind-boggling to me. So that would be one thing. I personally don't think it is John Bull's responsibility to direct, inform Mr. Finling how to proceed with these penalties. If he needs I've still never even been clear on who his counsel is, whether it's Mark Shapiro's firm or Mr. Finling's firm itself, and who's advising him. But we believe, and somebody can correct me if they disagree on the other side, we all believe this is his problem, his making. Yes, Mr. Bull participated in getting the returns filed, but this is Mr. Finling's problem and his problem to address. And we're all going to have a problem, I think, adding to the damage claim if these don't get abated, or even if they do, is going to be whatever fees are incurred that are arising from his neglect to begin with. But I don't think it's John Bull's place. We don't want anybody else to end up having a finger pointed at them that somehow they're responsible for the penalties or the penalties not being abated. We all look at it like it's his problem. He ought to move forward. And if he needs other professional help in dealing with the IRS on what's probably going to be a very uphill climb to get any sort of an abatement, because they didn't get filed because the receiver just neglected his duty to file them. But I think that's his job. I think that he ought to move heaven and earth to get that request out on the ones that are out there. The total, the roughly $95,000. I mean, whatever arguments he's going to make to request the abatement are going to be the same on the others, but no reason not to get them out now. Particularly when we all want to move this case forward, like Mr. Cleaborn said, and get this case, to be sitting here today and not one thing has been done other than he made some phone call to somebody who couldn't help him and talked to Mr. Bull this morning, to me is not satisfactory, is not sufficient. And so I don't know whether the court I would say get the request out, in the next week or two. And let's just get this thing moving, because once we get to a point where the request is not approved, or maybe sooner, I got to think about it. Maybe we'll all file something to bring this issue before the court, because I think the likelihood is they will not be abated. And the court will then have to determine whether this was Mr. Finling's responsibility as we all think, or not his responsibility as he thinks. And as far as the overpayment and the judgment, I didn't pull it. I'm not trying to spend a lot of money in this case, but I know the judgment got entered quite a while ago. And yeah, if he wanted to file some sort of, supplementary, post-judgment revised judicature act, some sort of collection complaint relating to the judgment, I'm not sure if that's what he should or shouldn't be doing. I don't know what attempts he's made to garnish or do anything, but here we are again on March 2nd, and he hasn't done anything. Whether he spoke to Mr. Bullock or he didn't speak to him, he has not done anything to light a fire and try to collect on that judgment, which you think he would do, since he's the one who made the mistake and overpaid it. So I don't, I guess the court can schedule, another status conference, and we can get an update again, and maybe a shorter time is better, since nothing happens apparently until we have one of these. But
Judge, if I could be heard. You know,
Sure.
I really tried hard to bite my tongue with respect to Mr. Scher's comments. His client knew that no K-1s were being issued, that he financially benefited from no K-1 being provided, and that he didn't pay income tax on the money that was being recovered from KFLP. Mr. Scher was involved in matters related to KFLP prior to the entry of the judgment, and I've tried to dissuade myself from bringing this argument into the court because I've been trying to focus exclusively on the matters before the court. But these continued attacks from Mr. Scher require some type of comment from me. Now, with respect to what I said, I think Mr. Scher must not have heard me because I said Mr. Bowl is the accountant for KFLP. I cannot take on the role of Mr. Bowl. And so as a result, I cannot assume his responsibilities as the accountant for KFLP. The communications are sent to him. The returns were filed by him. He's the one with the financial expertise to let me know whether there's some action I should be taking with respect to KFLP. And I was not attempting to disavow myself of any responsibility for the effort that I committed to, which was to abate the penalty. Now, if Mr. Bowl and his expertise suggests that we should write a letter now, this is the first time I've heard it, and I will do it. And I indicated to the court the timeline I would provide for it. With respect to the efforts to recover, I also gave the court a timeline as to what actions I would take. I continue to get these type of resentful comments from Mr. Scher. I don't know why. I try to keep it at an even keel, but that's unfortunately not been what I've been able to accomplish. I understand the desire to get all this done. But as Mr. Bowl said, the returns haven't even completely been processed by the Internal Revenue Service. The notices he provided me did not give me any indication that there was some action to be taken, some time period, some limitation that Mr. Scher had talked about earlier. So with that, as I reiterated, I will follow up on the phone number that Mr. Bowl provided after my Form 56, which is the appearance of a fiduciary with the IRS. I will follow up with the IRS in conjunction with his comments. I will work with Mr. Bowl with respect to drafting a letter that he finds appropriate and suitable with his comments, with my efforts within the next 10 days. And within the next 30 days or less, the complaint that I've drafted, which I have to finish, will be filed. And I'm saying as an officer of the court, the complaint has been drafted. It took some time for us to get records back from our IOLTA account to find out where the checks were deposited by Mr. Lenchner, to find out what account which belonged to his son, and the present status of that company. I've drafted the complaint. I will continue to refine it and finish it, and I expect it to be much sooner than 30 days. I apologize to the court. I've really been trying not to go here. I'll answer any other questions the court may have. I think my time frame is reasonable. It holds me accountable. It describes the specific actions I'm to undertake, and I hope it's satisfactory to the court. Thank you, Your Honor.
All right, thank you. Mr. Nelson?
Yes. So I would just like to just remind everybody of the orders we have in this case. Number one, the receivership order gives Mr. Finling it gives him exclusive control of everything over KFLP. In order for anybody to do anything, we needed an exception to that receivership order, which is why we all got together, stipulated to an order that authorized Mr. Bowl to prepare these tax returns and Mr. Sheldon Korn to sign them. That was, as far as I recall, the scope of Mr. Bowl's authority. Mr. Bowl doesn't have an obligation to tell Mr. Finling what he should or should not do. His sole responsibility in this case was to prepare the tax returns. Once they were returned, once a notice was generated, he was supposed to forward it to Mr. Finling, and that's what he did. And so I have full confidence that if Mr. Finling asked Mr. Bowl, hey, what form should I fill out? Mr. Bull would respond courteously and say, this is the one I would fill out. But Mr. Bull already wears 3 different hats in these related proceedings. He is the CPA for my bankruptcy estate, Mr. Smith's bankruptcy estate, well, our respective clients. And he's got this role as the tax preparer for KFLP. I just don't think he can add one more hat, which is advising Mr. Finling about what he should or should not be doing. And I don't believe the tax preparation order we have carving out an exception to the receivership order authorizes Mr. Bull to do that. And obviously we can change that. But at this point, I think Mr. Bull's only role is to possibly call the IRS and ask, just confirming you've received the tax returns I've submitted, or do I need to resubmit them? And then relay any notices. I do firmly believe that is Mr. Finling's obligation, not just a courtesy, that he address these penalties, because he's the one court ordered by the receivership order to engage in all control over KFLP. Other than that, I really do my best to be courteous, and I can tell you that it is frustrating that Mr. Finling does not respond to our emails. And it's not just Mr. Scheer. I would just ask that he make a better effort to respond to these emails, even if some of them are unpleasant to deal with. I will just end with that. And in terms of moving forward, I just think we need a deadline for Mr. Bull to contact the IRS to get the status on the unfiled returns. Mr. Finling to do something about the ones we have. And it sounds like he wanted 30 days to file a complaint. I would just hope that if the complaint is the only thing he needs to do, great, but I suspect there are other things he could do to move that along further. And what that timeline is, I don't know.
Your Honor, but first, I want to extend an apology to all the attorneys for the lack of communication. I apologize. Sometimes I call it the tsunami, where I'm overwhelmed with emails and I'm not prompt about responding. And everybody deserves an apology for me to the lack of communication that has taken place. With respect to Mr. Bull's role, I may have mistakenly concluded that by filing the returns that Mr. Bull would be following up. Previously, I had engaged an accountant that everybody approved named Kurt Mueller. And I will, after this hearing, contact Mr. Mueller to assist me in taking action so that there's no expectation that Mr. Bull has any responsibility of representing the estate with respect to the filing of any abatement request. So that will ensure that I'm not looking to Mr. Bull for assistance. That may have been a misunderstanding on my part with respect to the fact that he filed the returns, that there would be more to take place, but I certainly respect Mr. Nelson's concern that it could create conflicts for him that are unreasonable for the estates that are involved. So Mr. Mueller would be the one who would be taking on that responsibility. I will not look to work with Mr. Bull, and I'll copy all the attorneys on my communication with Mr. Mueller with respect to the actions I'd like him to take, and then they can participate in the discussions with respect to abatement. With respect to the proposed timeline for the filing of the complaint, I would ask for 10 days. I don't think 30 days is necessary. I offered that as a kind of a uncalculated amount of time. I think I'm far more along with what needs to be done that I don't need 30 days. And I'll answer any other questions the court may have. I'm doing my best to address everybody's concerns, and I apologize if I misunderstood Mr. Bull's role, and I appreciate Mr. Nelson's concern. And frankly, I'll be in the best position to move the abatement forward by having Mr. Mueller work with me on it rather than me taking the responsibility solely by myself.
All right, thank you, Mr. Smith.
Yeah, thank you, Your Honor. My concern, and it seems to have been addressed a little bit today, is the lack of communication from Mr. Finling. Although I haven't been emailing him directly, I've been participating in emails through other counsel and receiving no response. And I think the frustration here is due in large part because we are not getting any type of updates from Mr. Finling about what he's doing, where he's at. And then today, hearing his update, it doesn't seem to be moving with expeditiously, I guess, which is a concern of mine. And so I guess my suggestion moving forward is we shorten the time period for these status conferences, maybe have a directive that he reports to us every couple of weeks to let us know what he's doing. But we really don't seem to get a good update until we have these status conferences in front of the court, unfortunately. So I'd ask for a shorter period of time for these status conferences.
Thank you, Mr. Cleaver.
I don't have anything to add. I think I echo especially what the attorneys before me have already spoken. I think the time frame that Mr. Finley has provided, I think is reasonable as far as some of the next letter steps and complaint steps. So nothing further to add on my end of things.
Okay, so what I'm going to do is I'm going to craft a status conference order coming out of, incorporating, I think, what everybody's had to say here today, including some of the timelines suggested by Mr. Finling. I think certainly having hearings, status conferences more frequently than every 6 months is probably a good idea. So I agree with all counsel in that regard. And then the order, will also address some of the communication concerns addressed by the parties. So I'll attempt to incorporate everything into that order. And so I think that will give us somewhat of a framework for going forward over the next 90 days. I will set this for another status conference at that 90-day mark. And I think we'll continue as long as the parties believe it's productive. Because everybody's spending their time, I can easily fit it into my docket as often or as infrequently as it services the parties. So we'll go forward with the idea that we'll meet every 90 days, again, until we reach a point where the parties either need to meet more frequently, we're having some type of substantive hearings being scheduled, motions and so forth by one or more of the parties, or we start to have resolutions and the parties don't think we need to meet more frequently. So we'll move forward from today. In 90 days, I'll issue that order forthwith, reflecting what we've discussed here today, and we'll go forward from there. That's all I have. Thanks everybody for being on the call today. Appreciate all of your time, and look for the notice from the court. All parties are free to disconnect.
Thank you, Judge.
Thank you, Your Honor.
Thank you very much, Your Honor.
Thank you, Your Honor.